Okay, welcome everybody to the Civics Project, and this is our episode on the Intent Doctrine. I'm delighted to be joined today by Mona Tawatao, and I'm going to introduce her in a moment in more detail, but I'd like to start with a brief land acknowledgement, and also not forget to introduce myself. I'm Beth Ribet, the Director of Repair and the host of the Civics Project. So Repair would like to acknowledge the Gabrielina Tongva peoples as the traditional land caretakers of Tavangar, the Los Angeles Basin and South Channel Islands. And we're grateful to have the opportunity to work for the Tarahatom, the indigenous peoples in this place. We pay our respects to Hanukvatam, the ancestors, Ahihiram, the elders, and Eohinkem, our relatives and relations, past, present, and emerging. So as noted, I'm delighted today to introduce Mona Tawatao, who is the legal director of the Equal Justice Society. She is a senior litigator and has 27 years of legal services experience with a current focus on impact litigation, litigation to create social change, specifically related to healthcare rights and related due process and language access rights of lower income Californians. Previously, she served for 12 years as Regional Counsel for Housing and Land Use with Legal Services of Northern California and co-lead of its Race and Equity Project. Mona received her JD from UCLA School of Law. We have that in common. And after which she clerked for the Honorable Consuelo B. Marshall in the U.S. District Court in the Central District of California. And as noted, she is the legal director of the Equal Justice Society and has served on its board and also serves on the advisory board of the Shriver Center's Racial Justice Training Institute. So Mona and I are going to be talking today, primarily Mona talking and me posing questions, but we're going to be having a conversation today about the Intent Doctrine. Before we do, though, before we explain that to our audience who's unfamiliar, I wanted to ask Mona to share a little bit about the work of the Equal Justice Society. What is it? What does it do?
Thank you so much, Beth, and I'm very glad to be here, and good afternoon to everyone who's here this afternoon. The Equal Justice Society is a national civil rights organization. Our mission is to transform the nation's consciousness on race through the law and through science and through the arts. And I think today we're going to be focusing a lot on the law and the science part and the relationship between the two. I do want to mention that our work with artists and working with them to put forward artistic presentations is very important to spreading the word and educating people, putting people in touch with our understanding of how racism works, its history, everything from slavery to present day racism, police killings, the things that we are confronting now, and that art is a very important way to, in addition to bringing lawsuits and challenging discrimination in courts, a way to educate and raise consciousness. The kinds of cases that we focus on currently are, many of them have to do with school discipline, because we know that students who are Black students and Latinx students in particular are disproportionately disciplined and get suspended and end up possibly in the, or more likely in the criminal justice system. So through our cases with our partners and the groups that we work with, we fight against that, the racially discriminatory discipline. There are other types of cases that we work on, but maybe I can talk about that later in the conversation.
I would love to hear more. I'd like to, especially for those of our audience members who aren't already familiar, discuss the Intent Doctrine. But before we do, I wanted to ask you to say something about the Equal Protection Clause of the Constitution, because I think that's important to understand to make sense of the Equal Protection Clause. I noticed the Equal Justice Society shares the first word of its name with that clause. Can you talk a little bit more about the intentions and conception of the Equal Protection Clause and how it relates to EJS's work.
Sure. It is really important to understand equal protection, the constitutional right to equal protection under the law, in order to understand the intent doctrine or intent standard. So under our Constitution, the government guarantees that everyone is entitled to equal protection under the law. So what does that mean? What that means is that the government is obligated not to discriminate against a person who is similarly situated to another person on the basis of race or what have you. And what is important to know maybe in the context of today is that under the 14th Amendment was enacted during Reconstruction after slavery was abolished. 13th Amendment abolished slavery. 14th Amendment the purpose of it was to ensure that Black formerly enslaved people are citizens and have the full citizenship have full citizenship in the United States and are entitled to equal protection to white people and all people. So equal protection is somewhat self-explanatory, but the part that's important is it's a government guarantee that we all have equal protection under the law, and the government is not allowed to, treat someone differently that's similarly situated to another person.
Okay, thank you. So let's get to our primary subject today, the intent doctrine. Help us understand it. What is it and how did it work in the United States?
The intent doctrine or the intent standard is a test that the Supreme Court created as a test for determining whether it's the test that they apply and that you have to meet in order to prove that your rights have been violated, that under the Equal Protection Clause of the Constitution. So if you have been discriminated against, say on the basis of your race, then this is the test that you would need to meet in order to successfully bring a challenge in court under the Equal Protection Clause. So I think the better way maybe to understand it is to talk about the case itself and the facts of the case that created or established the intent standard. And the case was decided by the Supreme Court in 1976, Washington v. Davis. In that case, 2 Black men applied to join the police academy in Washington, D.C. And one of the tests, or there's a series of requirements in order to join the academy, and one of the requirements was a language and vocabulary test that they were able to show statistically that Black applicants were not able to pass that test and in great numbers compared to white applicants. So many more white applicants were admitted, and that test was a barrier. The statistical analysis was very solid. It was there, and in fact, the Supreme Court agreed. But what the court said is that even though that is the case, so you have this policy, you have this test, and it has a disproportionate, very negative impact on Black applicants, in order to prevail or to prove discrimination, you have to show that there was intent. So there was an intent to discriminate by the police academy. And so that is, in a nutshell, what the intent doctrine is, the requirement that to prove discrimination under a challenge under the Equal Protection clauses of the Constitution, you have to prove that the defendant or the perpetrator that you're alleging, the perpetrator of that discrimination, it had the intent to discriminate against you. And the problem with that, I was actually talking to my brother-in-law yesterday about this, telling him, oh, I have this presentation, and he asked me what it's about. And when I explained the intent doctrine to him, he said, wow, that's an impossible standard because we know that that's not really how a lot of discrimination works. And so that is exactly the issue with the intent doctrine, is it creates this very, very high barrier to be able to prove a discrimination when you don't have someone, using an overt racial slur, or, there isn't a smoking gun. But we know that so much of racism does not occur that way. I mean, there's unfortunately a lot of overt racism, and we have to fight against that. And maybe a lot of us are parts of various movements and efforts to do that, but there's a lot of discrimination that occurs that is not overt, but nevertheless prevents people from getting jobs and can even harm people physically, or can be a matter of life and death. So that's the problem. I kind of jumped to what the problem with the intent doctrine is, but it's hard, since one of EJS's missions is to dismantle the intent doctrine and to change the courts such that, and the law such that the law reflects the reality of how a lot of racism operates, structural racism operates in our world today. It's hard not to talk about the two together.
Mm-hmm. Yeah, I'm thinking about how difficult it would be to meet that standard anytime that you have a defendant in a lawsuit under the Equal Protection Clause who isn't admitting that they intended to discriminate. Like, how often would an employer who's engaging in race discrimination, for instance, say, oh yes, I discriminate against my employees? What are some of the things that people have to do in order to try to prove intention? Like, what has EJS tried?
Yeah, well, that's exactly right. Sometimes, there is that does happen, but a lot of times what you have is what is called like a neutral policy, or something that on its face nobody is saying, Latinx people cannot live in this mobile home park, or Asian people need not apply for this position. Nevertheless, because of the way that the policy operates, it has the same effect as if you were to do that. But I think the important thing to know is, there's two things. This is a big barrier to justice. So I think we have to acknowledge and really emphasize that the requirement to prove intent to establish an equal protection violation is a very big barrier that we need to do everything we can to challenge. And we're in a very difficult environment to do that. But the other thing is, there are civil rights laws that you don't have to prove intent for. So for example, under the Federal Fair Housing Act, if you're able to show a disparate impact, and maybe I should go into what that means a little bit, but you don't have to prove intent to prove housing discrimination if you bring a claim under the Federal Fair Housing Act. So I think one important thing that EJS does is preserve where we have a better standard, a standard that actually makes more sense. That's what, a lot of the work we do is to preserve that standard. But going back to, your question, Beth, about equal protection, the way the case law, I won't say fortunately, because it is so far from what needs to be the state of the law regarding equal protection now, because of what we're dealing with as a society, and this sort of reckoning that we're in. And it seems to make no sense whatsoever, given what we know about structural racism, given the death that we see that's caused by racism. It is obsolete and immoral. I would go so far to say. But there are, you know, these incremental, I guess, measures, or there are cases that have been decided since Washington v. Davis that kind of spelled out a little bit more what the court actually means when it says intent. And there's a case called Arlington Heights that laid out some factors that say, well, you can show certain, if you can establish certain factors, then you can, you know, you don't have to have a smoke. You can use indirect evidence in order to establish intent. So if if you're suing, let's say, a school board, and the school board does something very unusual in creating a disciplinary procedure, that's very, they don't do business as usual, but they take some strange procedural steps, that can be evidence that of intent. So you don't have to have a school board member saying, you know, we are going to discipline Black students more harshly. And you know, of course, you almost never see that, but nevertheless, the policies or the practices have that same impact. So if you're able to show that there are sort of off or unusual policy decisions that are made, or policy steps that are taken, that can be evidence of intent. Maybe I should talk about the standard that exists for the Fair Housing Act, and that we want to see replace the intent doctrine. Would that help?
That would be terrific.
Okay. Yeah, so the standard is called disparate impact. And what that means is, what we really want to see is the ability of people who are experiencing discrimination to be able to show statistical evidence, like the two applicants did in Washington v. Davis. And when you can show that through statistics, that there's a disparity, or a great disparity, that a great disparity in the treatment of one group of people compared to another group of people, to the harm of the people who are showing that disparity, that they should be able to, that should be enough to prove discrimination, and to prove that, you know, to get an order from the court that the policy needs to change. And so that is one of the factors, even though courts for equal protection still require that you have to prove intent. What intent means is you can show it through indirect evidence, and the statistics are a factor. They can't be the only factor. So you have to show more than that. But so what we do is, if we're forced to have to deal with the intent doctrine, which we are, then we try to push that factor as much as we can, and try to use the statistics and the other factors as much we can, operating within these constraints. So, but then so that's one side of it, like operating within the world that we have and pushing the envelope as much as we can, versus the other piece of it that we work on, which is trying to replace that doctrine with one that makes more sense given the way discrimination actually works.
And can you tell us a little bit about the harm and the impact? What has happened since Washington v. Davis? What effects has the intent doctrine had on efforts by racial justice lawyers and by other civil rights advocates, civil liberties advocates, to use the Constitution, or particularly the Equal Protection Clause?
It's been really very damaging and very devastating. I think one of the most stark examples is the McCleskey v. Kemp decision that, you know, in the same vein was decided 11 years later in 1987. And in that case, the court determined Mr. McCleskey was facing the death penalty, and he challenged the constitutionality of the death penalty based on really meticulous statistics that were gathered that showed that in the state of Georgia, Black people were executed, Black people convicted of capital crimes were executed at a far, far disparate rate compared to, white people who were similarly situated. So again, a not equal protection under the law. And even acknowledging that there were these, basically, if you're Black, and especially if you're convicted of killing a white person, then that would be the determinant as to whether or not you were executed or faced the death penalty or not. And what the court said was, well, those are statistics. Yes, they exist, but nevertheless, you didn't show, Mr. McCleskey didn't show that there was any intent on the part of anyone in the, anyone in the prosecutor's office or in the criminal justice system that led to that result. And so because you couldn't show that despite this overwhelming stark evidence, he was not able to prevail. And that in turn just really places a huge barrier to challenging racially devastating and incredibly inequitable outcomes, despite all the statistics that we're very aware of outcomes in criminal trials and throughout the system of the criminal justice system. So that's one of the effects that has, and since 1987, the reason that it's so difficult to make challenges to racial unfairness in the criminal justice system can be traced back to McCleskey, which in turn can be traced back to Washington v. Davis.
So in essence, what I'm hearing, just to hopefully help translate to our audience that didn't go to law school, part of what I'm hearing is that the intent doctrine makes it extremely hard for a plaintiff to demonstrate that racism is occurring because it's so difficult to prove discriminatory intention, and because a lot of racism doesn't have to have conscious intention. Can you talk more about that? How does racism work without conscious intention?
Yeah, thank you for asking that question, because I really wanted to get to implicit bias and unconscious bias. What we know now through decades of social science is that so much of our decisions, our actions are not actually dictated by what we're thinking consciously, but the vast majority of our actions are dictated by our subconscious or unconscious. And implicit bias refers to unconscious bias, which comes about because of stereotypes and the bombardment of the media and just everything that we take in, our brain takes in. And implicit bias refers to stereotypes or attitudes that we're unaware of, but nevertheless affect our behavior. So I think a really good example of this is the infamous or famous resume study. This was in 2004, and there have been a lot of studies since then. And the study involved, many of you may not be aware of this, but the study involved sending out nearly identical resumes, not real resumes, to a number of firms, and either they had the name Jamal compared to Greg for males, or Emily compared to Lakeisha for females. And so traditionally, or names associated with white people versus black people. And the gap in callback rate was 50% lower for Black people. And there was likely no overt policy on any part of the prospective employers, but nevertheless, that was the outcome. So that's one example of how implicit bias can operate. And since we know that implicit bias occurs in all of our institutions because of all the social science studies that have now been published, it makes no sense for an intent standard to still, still be the standard. And one of the things that EJS works on is implicit bias trainings and educating people about how implicit bias, unconscious bias work, and how they can actually, if we all, and what we know now is we all have implicit bias, and some of it is harmless. Like if I say, I like, to spend my time during the pandemic watching or listening to music more than watching movies, and it turns out that I actually have an implicit bias in favor of movies, that doesn't hurt anybody. But if I have an implicit bias against Asian people and I don't know about it, it is going to, even though I'm a good person and I think I'm a good person, and I think of myself as an egalitarian, it's still going to affect the decisions I make if I'm in a decision-making position. And that in turn, so that's not just decisions, that person, we all make, some of us are in the policy-making field, or we make decisions about who gets in and who doesn't in different fields. And so if we all have implicit bias, and some of that is implicit bias when it comes to race, then doesn't it make sense for the courts to operate in this reality as opposed to this unattainable, almost unattainable standard of proving intent?
Mm-hmm. Absolutely. I'd love to know more about what EJS is working on now. You mentioned advocating to replace the intent doctrine with a disparate impact standard. Are there particular, and you mentioned obviously doing more training on implicit bias. Tell us more about your agenda in the coming years. What's a pathway to hopefully abolish the intent doctrine? And granted, that's no small order with our current Supreme Court.
Yeah, I mean, I think we have to acknowledge the reality of the current Supreme Court and how difficult that will be. And Justice Roberts in particular, who's the Chief Justice of the Supreme Court, he's a big proponent of colorblindness, and a colorblind sort of approach to the law ignores the history of slavery and the history of oppression of people of color in this country. So it's a tall order. One of the things that we do in our work is that we focus on where we can, pressure points where we can further develop the disparate impact standard, which is again the standard that where we think you should be able, if you're able to amass the statistics and to show that the policy creates a very big statistical or a significant statistical unfairness, that's the standard that we're shooting for. So it's developing that further in fair housing cases. It is in places like California where our equal protection, our California Constitution, equal protection does not have an intent standard or has an opening to move beyond the intent standard. So working in those forums and bringing cases in those forums to further develop the law so that maybe in turn, if there are changes in the Supreme Court in the near future or the further future, that we will have those opportunities and have the know-how and have developed more case law, say in California, where we have opportunities to push forward the proper standard that can inform what happens at the federal level. But I say that, fully acknowledging that we have a very difficult, there's a difficult path. I think the other thing I want to mention is, talking about implicit bias, we don't just train about that, but we, in our cases, for example, in our discipline cases, some of the remedies we seek include having experts come and train, administrators and staff people on what implicit bias is, and also importantly, to tie one's own implicit biases to the decisions and policies that an agency, say a school district, might make. And so we not only talk about it in trainings, but we bring it into our cases. We put it into our legal papers, explain what it means and how it can affect, for example, you know, how a school district might handle discipline, and why it's important not to have police in schools, because then if you eliminate, well, I mean, we shouldn't have police in schools. So let me just say that. And we support organizations who are doing really important work to ensure that police and, you know, school resource officers are no longer part of school life. But it is, you know, so the work that we do includes bringing implicit bias into our cases and bringing ways to address bias into our cases directly, and asking the court to make orders or reaching agreements with the people that are being sued to bring implicit bias training and analysis into fixing the problem.
So what I'm hearing is that the Equal Justice Society is both working to overturn intent doctrine, but also to advance anti-discrimination work in the law, working around it, you know, given where we are right now. Is that about right?
That's right.
Okay, great. And I want to help again, you know, this might seem like an obvious question, but why is it so important that the Equal Protection Clause is failing to be accessible, essentially, for a lot of people who are experiencing racial injustice? For instance, how would you respond to someone saying, well, if you've got other civil rights laws that don't have the intent doctrine, or if you can go to state court, why does it matter? Why do you need the Constitution to recognize racial injustice and racism more broadly? So why is this so important?
Well, lots of reasons. One is that, so with the Fair Housing Act, as I mentioned, that's one of the better avenues to justice. Still lots of challenges, still so much work to do, but one of the better avenues to justice if your case happens to fit into the Fair Housing Act. But there's so much so many systems in our society that really the best redress or the best remedies that you could get would be under the Equal Protection Clause. And so there's so many areas that are not covered by other civil rights laws. And if you rely on state laws, in California, I would say, you know, maybe relative to other states, we have some options here, but there are differences between state laws and what you're able to do in a state and what you're able to do on the federal level. And the Constitution is the law of the land. And so I think what we hope for and are fighting for is a world where, in a country where there's uniform equity, and that, you know, somebody living in Mississippi who is experiencing race discrimination has the same ability to fight that, and the same tools to fight that discrimination as somebody living in California. And so I think, and then I mean, if I can speak to the moral part of it, particularly the 14th Amendment, the purpose of it is being utterly frustrated, to say the least. The purpose of it was to repair the abomination and the damage of slavery, and for it to be used now and to be interpreted now as effectively blocking so many people from equal protection, Black people and people of color, women. It is just, you know, it's fundamentally not what the 14th Amendment was enacted to do. So I think there's so many wrongs that can't, you know, for which the Equal Protection Clauses, if applied and used in the way that they were intended, would offer protection that isn't otherwise available. Otherwise, we have to talk. Maybe there's legislation that could be done, but that is a whole other. And I think we have to look at that. But that is a whole other challenge.
Mm-hmm. So one of the things I'm hearing is that without an adequate basis in constitutional law to challenge race discrimination, anytime a state isn't recognizing it or there's no area of federal law that's addressing it, effectively that's going to mean there's not much people can do to use the courts to challenge injustice.
Right. That's absolutely right.
Okay, thank you for helping us understand why this is urgent. What would you recommend to folks who want to learn more? Do you have a book that's useful for kind of lay learners who want to start to make sense of equal protection law in the United States and the Intent Doctrine?
Yes. Well, I shared just a little while ago, I shared a couple of pieces with Beth. One is authored by Eva Patterson. It's the Equal Justice Society president and co-founder. And it's about litigating implicit bias, and it talks a lot about the Intent Doctrine. And for those who are on today, I believe Beth is going to be able to share that. So I recommend that. It's a nice 3-piece, very succinct, and really it is sort of like our ethos. It really just describes what our mission is in this short article by Eva. And I would also recommend the book Simple Justice, which is a long book. Maybe I shouldn't, not a very good salesperson, but it is a really a landmark study on the landmark case, perhaps the most famous case in US legal history, Brown v. Board of Education, and it really breaks down, it's not directly on the Intent Doctrine, but it breaks down and really discusses both history and the relationship between the law and science, and the famous doll experiment that was used to help bring about the outcome in Brown v. Board of Education. And it was written in the 70s. There was an update written in 2004 that describes the changes in the Supreme Court and the administration in the country that have, made integrated schools a continuing goal, but something that is still unfortunately far away. But I think it covers a lot of the things that we've been talking about and goes into some history in ways that could be helpful and interesting to people.
Great. And just to share the full title, if anyone listening would like to read the book, the author is Richard Kluger, and the full title is Simple Justice, The History of Brown versus Board of Education and Black America's Struggle for Equality. Great recommendation. Thank you, Mona. I'd like to just know if there's anything you would recommend for folks who want to support EJS's work, the Equal Justice Society. Are there ways to get involved? Do you have petition drives? Do you have regular donors, things like that?
Yes, well, we welcome people to support us with their generosity. We are a surprisingly small, we say small but mighty organization, and more resources to fight back against the Intent Doctrine and its effects, and to fight for racial justice for the students and the families that we represent in our school discipline cases, for college students who are applicants to college who we are fighting for to, we actually got an injunction with working with partners to stop the racist application of the SAT and ACT in California. And so things like that require resources. And so we would really appreciate you visiting. If you Google Equal Justice Society, you will find us. We also have events that I talked at the beginning about bringing together law, science, and art, and we have events that often focus or feature artistic presentations, and we could utilize volunteers for those events, and we host or participate in presentations. And so if you join us and get on our mailing list through our website, then you can find out what we're doing, find out about our cases, and find out about our advocacy efforts that go well beyond just the court.
Wonderful. And for our live audience, I've put the web address for the Equal Justice Society in the chat. For our listening audience, you can find them at equaljusticesociety, that's one word, .org. Mona, I want to thank you so much for joining us today. It's a vital subject, and I'm personally really grateful for the work that HIS continues to do, and for the level of commitment and clarity that you all have been bringing to the work for some time. So I hope a lot of listeners will start getting connected to your work. Again, I want to thank you so much for joining us. For our listeners, please come back next week if you would like to join us for our episode on campaign finance. That's on the 25th of April. And then on May 2nd, we'll be having an event on children's rights and child welfare with special guest Kim Hai Pearson. Then May 9th for family and medical leave, May 16th for Veterans Affairs, and we just confirmed that we'll be having disability rights attorney Deborah Dorfman joining us on May 23rd to talk about disability rights in the United States. I also just want to share our upcoming film options. Will be screening for a monthly film screening, The Great White Hoax, Donald Trump and the Politics of Race and Class in America. The last Wednesday of this month, which it will be the 28th, and that's always at 4 o'clock Pacific time, 7 Eastern time. And for next month, we've just confirmed we'll be screening United States of Conspiracy, and we'll be doing that on May 26th. So keep tabs on our events page. For those of you who are podcast listening, you'll see it in the description for this episode. And for those of you joining in Zoom, you'll receive a link to our events registration page after. And again, I just want to thank everybody who turned out on a Sunday for the Civics Project. Really appreciate your energy and commitment. And again, to just express enthusiastic appreciation to Mona Tawatao for bringing her insight and work to us today. Thank you, everyone.
Thank you. It was my pleasure.
Yeah.